Good afternoon.
Good afternoon, Oh, please.
Thank you for joining PHCA for today's webinar, COVID-19 Liability Claims, How to Minimize Risk of Litigation. I hope you are doing well and staying healthy during this ongoing challenge with COVID-19. We recognize the extraordinary work that you've been doing through this crisis and thank you for all that you're doing. I'm Wendy Johnson with the Pennsylvania Healthcare Association. Before we begin, I have a few housekeeping items to cover. PHCA offers monthly webinars to members to receive updates from department staff on regulations, learn from industry experts on current trends and practices, and to gain a better understanding of practical application tools to equip you so that you may continue to provide the highest level of quality care possible. This webinar is being recorded and will be made available on the PHCA website. The webinar has been approved for one continuing education credit for PHCA members. Credits will be uploaded to NAB within the next 2 weeks for those who have provided us with your unique NAB number, and I will be sending attendance certificates as well. A survey will be launched at the close of the webinar. Your feedback is important to us and our speakers, so please take a moment to complete the survey. All attendees will be in listen-only mode. However, throughout the presentation, please feel free to submit your questions using the questions pane on the right hand of your screen, and our presenters will address them at the end of the presentation. Today's webinar will be presented by Bill Mundy and Amelia Curotto, both with Burns White. I'll now turn the webinar over to our presenters.
Good afternoon, everyone. I'm Bill Mundy, obviously, and don't probably look like Amelia. You can tell how excited we are for this seminar because I spoke over Wendy when we began this. We actually presented this at the yearly convention last year, also virtually, the COVID-19 lawsuits, what to expect. And when we first started talking about the spring and what to present, it was amazing going over the last 6 months at just how much has changed regarding what we can expect with the lawsuits, what's been going on with lawsuits and liability protections, and also what you can do to minimize risk as well as to, hopefully avoid lawsuits altogether, but if you are faced with it, to be in the best position to address it. So today's presentation is going to go over some of the stuff that we talked about last year, but also add to that about what we have learned. There'll be 3 parts essentially to the presentation. The first will be the overview of Governor Wolf's order. We talked about that before. Governor Wolf issued a second immunity order, but as Amelia will tell you, there's not really much to it. And some of the legislation that's been going back and forth with regard to protections for healthcare workers. The second thing we'll talk about is the litigation issues. Now we'll get into a little bit of law, and you might think about why do I have to know any law, certainly as a provider. But I will tell you that in doing long-term care for 26 years now, med-mal for 30, and one thing about the area of law that I practice in is that you learn a lot about the medicine. It's really important to understand the medicine. Obviously, I have to know about the genesis of wounds and how you treat them, et cetera, in order to effectively represent you. So in a sense, I'm going to flip it a little bit with this presentation because I wanted you to know a little bit of the law, a little bit of what goes into these types of lawsuits so that you're better able to understand why certain things should be done and hopefully to avoid litigation. The last thing we're going to talk about is best practices. So everything above it will feed into best practices that you can do at a facility level to protect against COVID lawsuits. So without further ado, our special guest star here is Amelia Curotto. Amelia is in my group, my practice group, and she is part of the COVID team. She has had her into her elbows in these cases and what is entailed. And so if you do have an actual lawsuit that comes up and we are handling it for you, Amelia will be the one to reach out to you and to go over the initial protocols that we have. So without further ado, Amelia.
Thanks, Bill. And again, we're going to go over the Governor Wolf's executive orders. The first one being the one from May of 2020. If you were with us last year at the annual convention, this will sound a little bit familiar. It is still in effect, and much like last time we spoke, we still really haven't seen much of any effect that it will have on litigation, but we'll still kind of go over the basics. So we'll go over, who's protected by the immunity, what actions fall within the scope of the immunity, and what the limitations are to the immunity. And just to kind of briefly overview before we get into it, as you're probably aware, executive orders are something that is allowed by the governor to issue, and there are certain different categories that he's allowed to issue these executive orders for. They don't have the force and effect of law, and it remains to be seen, particularly with this executive order, how a court will interpret the immunities that Governor Wolf has promulgated with this one. But as we'll see, at least with the nature of the lawsuits that we see against long-term care facilities, it might not have any real effect in the types of lawsuits that plaintiffs can bring. So first of all, who's protected by the immunity, and whether our superhero healthcare providers are covered by the immunity. So the executive order specifically says that the providers that are covered are any individual that holds a license, certificate, registration, certification, or who are otherwise authorized to practice a healthcare profession or occupation in Pennsylvania. Pretty broad, and thankfully it's pretty broad, at least as to certain licensed individuals. So that would include, doctors, nurses, nursing assistants, therapists, but most of the employees that are within your facilities. The big question, though, is, are facility operators covered? And you can advance the next slide. And unfortunately, the order does specifically exclude facilities and entities in which the covered individuals work. So the immunity is limited to the individuals only. So what that means is that the operating entities, management companies, parent corporations, subsidiaries, any other related entities within the facility's corporate structure are not directly covered by the immunity. And as you probably are aware, unfortunately, if your facility has been sued, those are the parent corporations and kind of the corporate negligence. Those are the entities that a lot of the plaintiffs' counsels will target. They usually will name the facility and every corporation that may or may not be related to the facility under the sun. So unfortunately, as to the litigation that we typically see with long-term care facilities, this executive order won't cover the entities that are usually named in these lawsuits. However, as to individuals, it may be able to provide certain types of immunity. So going along with that, what actions fall within the scope of the immunity for these individuals? And now we're going to get into some fun, political speak, which is going to come up a lot in today's conversation. So the immunity allows for any acts or omissions undertaken in good faith while engaged in emergency services or activities or disaster services activities as related to the Commonwealth COVID disaster emergency response. What does that mean? I mean, there's kind of a whole lot of buzzwords, and it doesn't really seem to say a whole lot. The big question is, what are these emergency services activities? What are provision of disaster services activities? And again, a lot of this is going to depend on when this specific executive order has been presented to a court, and the court will specifically start to analyze it, which we have not seen to date for reasons that Bill will touch on in a little bit in advance. So we don't know exactly, and again, as you also are probably aware, with a lot of litigation and laws and all of that, it just depends on each situation and whatever judge you're in front of and whatever they're thinking that day. So we don't have a real, concrete definition of these emergency services activities or what kinds of activities are going to be covered by the immunity. However, we do have a little bit of guidance in some sorry, you can go back to the previous slide. We have some guidance in the in some other Pennsylvania law that emergency services has been defined as preparing for and carrying out functions, including medical health and services and resources management to prevent, minimize, and provide repair of injury and damage resulting from disasters, including all necessary functions to carry out the activity. Again, really broad definition. So even though it kind of distills it a little bit, again, it's really just going to depend on each individual situation and once we get some guidance from courts on this. But as to this immunity, it has to be related to the COVID-19 response. And again, what does that mean? To us, we will want to argue that that involves everything from supplies, PPE, staffing, anything that's necessary to, operate the facility and provide care to the residents in response to the COVID-19 pandemic, whether that's direct care to residents or providing certain services or supplies in order to do that. But again, that's an issue for another day in front of a judge. But that's what we're here for. The lawyers are here to just kind of battle that out, and we'll just see as case law just kind of develops on this issue, whether we can get any sort of clear indicators as to what exactly this immunity will apply to. Governor Wolf first stated that it would only be in effect during the time frame of the state of the disaster emergency, effective as of May 6th. As you know, Governor Wolf's been consistently renewing the disaster state, most recently in the middle of February for an additional 90 days, which is currently probably up around the end of this month. As far as we know, it's probably expected to continue. That kind of provides a long range of activity that could potentially be covered. So then limitations of the immunity, we kind of went over, kind of goes hand in hand with some of the overly broad language that's in there, and there's some language that is specifically excluded. So the immunity doesn't extend to healthcare professionals rendering non-COVID medical and health treatment or services. Again, that remains to be seen. What exactly it means, it's going to depend on each situation. But as we've said before, there's a lot of different activities that are indirectly in response to the COVID pandemic that may not necessarily that may not necessarily direct an individual's treatment of COVID-19. So there's a lot of different nuances here, a lot of different avenues where we might be able to use the language of the immunity to our advantage if an individual is named. And of course, and then it says it doesn't extend to acts or omissions that constitute gross negligence or willful misconduct. These are buzzwords you're going to be seeing a few times today. And you've probably seen that in some complaints that have been filed, these gross negligence or willful misconduct. Gross negligence has been generally described as extreme indifference or reckless disregard for the safety of others. It's something that's more than just the ordinary negligence, more than simple carelessness or failure to act. It's this willful, intentional behavior done with extreme disregard for the health and safety of others. And again, these are all kind of, whether there was gross negligence or willful misconduct, it's just going to depend on each individual claim. So that's the basics of the May 2020 order. Governor Wolf did issue a second order in November 2020 that is actually, for as much as I was ragging on the May 2020 order, the November 2020 order is even more worthless in my opinion. So in November of 2020, the Pennsylvania legislators passed a bill that would allow certain civil immunity to healthcare providers, schools, restaurants, other businesses from civil lawsuits related to actual or alleged exposure to COVID-19. And Governor Wolf vetoed that bill, saying that, he thought that it was too broad in the protections that it provided. But in response, he issued a second executive order regarding certain immunities to lawsuits. So that second order it's less specific as to healthcare providers, and so it has it's more vague and less specific to healthcare providers. So it kind of includes businesses, including non-for-profit businesses, state employees, local health departments, local law enforcement, and other government agencies. The one benefit to this is that it actually does include corporations and other corporate entities, which the May 2020 order didn't provide. However, the immunity is pretty limited. It's entitled to immunity as related to the Secretary of Health order regarding universal face coverings and masking. So the Secretary of Health issued this order in November of 2020, outlining a bunch of different requirements and guidelines for universal masking, social distancing at different establishments and businesses. So it's very vague. It doesn't really say a whole lot. It says that you're provided immunity if you try to comply with this order, but doesn't exactly specify any additional conduct or any language that's included in the order. Again, I mean, I think that this is just kind of typical politicians writing things when they don't want to deal with anything. So, and trying to kind of, patch up when Governor Wolf vetoed the bill saying, oh, I'm going to issue another executive order, and then came out with this, which doesn't really say anything. And again, this willful misconduct, gross negligence, recklessness are excluded from this immunity. And it also excludes claims raised by employees against employers, including workers' compensation actions. But again, this does even less than the first one, and obviously it's something we'll keep in mind moving forward. And we've also haven't seen any courts really interpret this to date. But again, really doesn't really say a whole lot, and really probably won't change anything about. Unfortunately, won't change anything about the types of lawsuits plaintiffs will be allowed to bring against facilities. So kind of just summarizing it up, bottom line that yes, there's potential in individual immunity for certain individuals named in actions from that May 6, 2020 order. As to corporations, there's kind of this wishy-washy November executive order regarding universal masking, but I think that is a little bit of a stretch, and again, unfortunately, doesn't really say a whole lot that will be able to help us. So overall, there's really no immunity or executive order regarding specifically the facilities, operators, and related entities. So it could prevent some individuals from being sued, but as we've said and as we've seen, usually the plaintiffs' counsels are going after the facilities and related corporate entities for this type of litigation. So at the end of the day, we'll probably still see the same types of lawsuits that we've been seeing in the past. But wait, there's more. There's still some fun to be had. The Pennsylvania legislature's not giving up, so they have passed, the House of Representatives has passed a second bill earlier last month. So in April of 2021, they passed a second bill regarding immunities for claims of COVID exposure, a little bit similar to the first bill that was passed. Again, gross negligence and intentional misconduct are excluded. And this bill does specifically protect healthcare facilities and nursing homes. There's also a provision allowing for compulsory arbitration for these types of claims. So the House did pass that, and it's currently being considered by the Senate. But as we've seen, the governor still has veto power and hasn't been a fan of extending a lot of immunities to healthcare providers in the past. So not sure if this will change his mind, but just stay tuned for what's going to happen with that. And so then with that, I'm going to kick it back over to Bill, and he's going to talk a little bit about, what to expect with these claims moving forward and best practices for preparing for when this all happens.
Thank you, Amelia. One thing I will say is that the PHCA, your partner in this, has been fighting the fight and struggling to get some type of immunities in place for healthcare providers and operators, because operators, as Amelia stated, will be the target of litigation. And so they're continuing the fight, and today that fight continues as strongly as it did last year when the first liability bills were passed. So hopefully, something will come of it. But I can tell you there are some proposals out there, some unique proposals out there. But again, the struggle continues, and you don't have a better partner than the PHCA for that. Moving forward, so what are we expecting then from COVID litigation? Now, some folks on the line may have experienced it. You may have received some letters and what have you. But let's talk about what we expect and where this is all going.
Someday this war's going to end.
Okay, what do I mean by that? Well, I normally, first of all, I'm a movie file. So if you call it the last time we did this in person, then hopefully this is the last virtual presentation we have to do. I'm a movie file, and I usually do different presentations with movie clips. So I always have to throw one in. So that's one of the reasons why it's there. But there's another reason. I usually use that in kind of concluding presentations about litigation and about things we need to do to say that, look, this will pass and we'll be done with it. And that particular clip actually has a kind of a dual meaning here. Right now, we see ourselves on kind of the tail end of the pandemic, hopefully. I mean, there's a lot of conflicting news, we should say, that is out there. And but we do know that, and Amelia will give us statistics later about the number of vaccines out there, over 100 million, and that it does look like the cases are going down, hospitalizations going down, the effect of it are going down. Most of the vulnerable population has been vaccinated, so all good things. And so we see ourselves kind of at the tail end, and almost that clip is like, someday this will end. Someday we'll be back to normal to a certain extent. But from a litigation perspective, we're just beginning. And there's a lot of uncertainty, wherein we have, traditional types of claims for wounds and such like that. We do know the course. We do know they'll happen. They'll happen over time. We try to minimize the risk. We try to do certain things about them. But they're your typical litigation. Here, it's a brand new frontier. And the thing about this COVID, a lot of people associate it with the Spanish flu from 1918, 1919. But it really has nothing to do with that, and it's not even close to being similar. And the reason being is because the health systems are, apples and oranges, night and day. The health system now that we have in place, especially for long-term care, is, frankly, was non-existent 100 years ago. And so the effect on it and the litigation environment is completely different. So we are dealing with, not only from a virus perspective, but also from a healthcare system perspective and from a legal perspective, something completely unique that we've never seen before. So when this first came out, as lawyers are wont to do, there was a lot of races to sign up cases. There were websites devoted, websites targeting certain facilities. We've sent some cease and desist letters to them because of the way they went about it. But there were a number of different entities. And what happened was a decision was made among a lot of the folks that normally do long-term care kind of cases. Some took a step back and said, it's going to cost us a lot. We don't know where this is going. There's a lot of uncertainty. And we're just going to stick within our normal lane and handle regular cases. There were a few that said, maybe there's something to this, and we'll take all those cases in. So there's been a concentration of smaller local firms that have taken these in. And then there's some national firms out there that just went for broke and said, we'll sign up everything, doing kind of all types of advertising for that. And they'll get the cases in, and they'll try to direct them to a local counsel. So that's kind of what's going on out there. All different types of claims potentially come out of COVID. Malpractice is what we normally deal with, and that's what you normally expect, a standard of care, or whether it was breach, whether there was injury from it. But there's other types of potential claims that are kind of on the cusp and kind of out there. Some more prominent than others. Resident rights, employer liability. The two big ones in this, this diagram would be malpractice and employer liability, where an actual staff member is injured or dies from COVID. And that's something actually we'll show you a little bit later in a lawsuit that was filed. But also board actions, surveys. You dealt with the survey issues, and administrative surveys, and premises liability. What's that about? Well, some of these claims actually can be considered not malpractice, but more from a facilities management, how you manage your facilities. So of all these, we expect 90% of them will be employer liability or malpractice type claims. The primary areas that we'll focus on and have focused on are infection control. That would seem obvious given that we're dealing with a virus. PPE, staffing, and staffing really, the argument on staffing has actually changed, and we'll talk about that in a minute. And keeping family informed. These are the kind of the primary focus. And so when we talk about some of the preventive measures that you can put in place, this is some of what we're going to be talking about. And a corollary to keeping the family informed is also some of the apology legislation that's out there, and reach out to families and keeping them within the orbit of knowledge that you have and what's being given to them. So we have the statistics are somewhat grim for Pennsylvania. I think there was 12,000 deaths in long-term care. You would expect, so where are all these cases? We see the liability, we see the advertising, we see the potential out there, so where are they all? Well, that's kind of interesting. This is where we'll talk a little bit about the law, but it's kind of an interesting story, but also why it hasn't gotten to you yet, but what we're expecting. So the main reason why things are held up is something called the Public Readiness and Emergency Preparedness Act. It's called PrEP Act for short. You might have heard it out there and people commenting on it. It was actually created back in 2005, and it was in response to potential terrorism, bioterrorism, those types of things. And basically it said the Secretary of HHS can make a declaration of a public emergency, and that countermeasures that are put in place to address that public emergency, which would include vaccines and such like that, might have an adverse effect, and that certain immunities should be given to healthcare providers for that. And that is the very bare bones description of what it is. A lot more nuance to it, but just to give you a sense of what that is. So, so what has happened with this litigation, one of the reasons some have been scared off, and it's been kind of a condensed to certain people handling these cases, is that you have this PrEP Act issue out there. So there have been a series of test cases. Right now, it's probably about 50 that are filed. Might be some more by now. Every day there's something new. But they were filed in the various jurisdictions throughout the United States, including in Pennsylvania. And they are immediately being removed to the federal courts, if they're not even filed in the federal courts to begin with. And they're being challenged under that PrEP Act to say that because all these things deal with countermeasures, how you dealt with an allocation of resources, that the PrEP Act should apply, and that everybody should be given immunity, and we all need to go home, and that's the end of it. That has not been very successful to date. Right now, about 36 cases in which this has come up and this has been challenged. The PrEP Act has been successful in throwing the case out in one case in the Central District of California. And that is up on appeal along with a number of other cases into what's called the Third Circuit, which here, Third Circuit, but circuit courts, which are the appellate courts for federal. And then above them would be the U.S. Supreme Court. So all these cases, these test cases, are kind of stuck there, while they're trying to determine how this applies, whether it applies, and what have you. Once they get through that, they'll go back to the states, assuming they survive, and then the state courts will have to get involved, and they'll probably be remanded to the state courts. They could stay in federal, but probably remanded. But either way, the next question is, are there any state-based immunities? Now, what Amelia told you was exactly true in Pennsylvania. A lot to do about nothing. And it's because the governor has put his foot down and said, we're not going to have these type of immunities here that shield the healthcare operators like they do in New Jersey, and they repealed the one in New York. But there's also something similar in Delaware. Here, we're going to let people sue. So that's basically what he's come to, that determination, and tends to be a lot of politics that are involved in that types of determination. So the legislature keeps passing these immunities bills but the governor vetoed the first and has threatened to veto anything that comes his way unless trial lawyers aren't involved at the table and give their blessing. So in any event, that's kind of where we are. So we expect when it comes back to state courts, we're going to be dealing with immunities a little bit, but they're not really going to apply in Pennsylvania. So we'll be dealing with other issues, standard issues, and that's kind of what we're going to get in the meat of what are these cases about and how do we prevent them. Now, the first thing you've heard about, I'm sure you've heard about before, is the concept of standard of care. So what is standard of care? Well, any case you've ever been involved in, almost every case that deals with a resident injury and a lawsuit is going to be about the breach of the standard of care. And standard of care here, as we talked about earlier, this is a whole new phenomenon. We've never seen anything like this, and certainly not in our current health system. So the question is, how is a standard of care going to be defined? How do you know what you were supposed to do? And you have to set that bar before you can breach it. So there's going to be this battle over what is the standard of care with COVID and what we knew and what we should have done. So what that really comes down to, from our perspective, is all the information that was coming down from the CDC, from the HHS, from the Department of Health, the local Department of Health, and all these different entities, even I guess you could say WHO. But the question is, from all this information, and there was an avalanche of information that was coming down, some contradictory, some changing day to day, but what came down and then what was actionable. Okay, so simple information may not be actionable, but there's certain things you learned about that you needed to take action. And then what action was taken and did you stick to it? And I think the best way to analogize it, just to make it crystal clear, is that if you think about when a resident comes in, the first thing you're going to do is to identify what are the potential problem issues, fall risks, what have you. And then you're going to come up with a plan of care, and you have certain standard interventions that you'll put in place and requirements for the different departments. So this is somewhat like that. It's a facility standard of care, and it's a plan of care for the facility to deal with this issue, which is COVID. So think about it in that frame of mind. Here is a pictorial, and it's a very basic one. This is just taken as a snapshot of documents that we have worked on and interactive type of things we have. Because when we talk about standard of care, the standard of care actually had changed over time. And you're going to see, too, with first wave versus second wave, it kind of changes as well. But the way we analyze this and the way we look at it is that you have all this information coming down and which ones are going to be important. So here's a pictorial of it. Every one of these little blue boxes, we didn't just throw this together and just say, hey, it looks like a lot of different notices. These are actually representative. If you were to clip on this on the interactive model, a notice would come up from CMS or HHS or something like that, the DOH, Pennsylvania DOH, something. And it would be a notice that was normally sent out to the healthcare providers. So it's an amazing amount. And this is just a snapshot of a very unique a very unique time. It goes on and on and on, but you get the point. And so what happens here when I talk about actionable, one of the first notices that most plaintiffs' attorneys talk about and point to is the February 6, 2020 memo from CMS, where it talks about certain preventions and precautions that need to be considered for COVID. And so you look at this document and say, well, this is a notice. This creates, the standard of care would be to recognize this notice, to act on this notice, and to put into place a plan to address the information that's in here and the concerns that are in here. And that if you didn't do that, then you breach the standard of care. So you can see we're almost, it's unique in that we're kind of setting the standard of care, and then we're saying whether it was breached. And so we want to be the ones to define the standard of care and show why we complied with it. So kind of take the initiative that way. That's why it's really important. So when we get the information from you and we talk about those things, protocols that are put in place and prevention measures, it's really important to have that information as it's developed. And we're still in this, even though we're in the tail end, we're still in it. And these are really important documents. So we'll get to that in a minute. So that's what we're talking about with standard of care, and that's how we're viewing this, as a timeline, information, actionable information, and what was done. So first wave, second wave. I alluded to this a little bit earlier, and what do I mean by that? Well, the issues that come up with the first wave, nobody knows anything about this virus, right? And then the information you're getting is kind of all over the place. Remember, like Amazon packages, you got to wait like 48 hours and then wipe them down with Lysol and all kinds of stuff like that. Well, it doesn't really work that way, and it doesn't transmit that way. But you get a little bit of information from one lab, and then everybody starts acting that way, and then we realize that you really don't have to worry about that. Same thing with masks, same thing with a lot of different things. So the information that was available before the first wave, which is primarily between March and the end of June of 2020, and the second wave, which struck first mainly rural more facilities in, say, November through January, are completely different. And the issues that were dealt with are different. And think about just two of the main areas that I brought up before. Well, number one, infection control is different because you learned a lot about it and what you need to do and what might not be effective. But let's face it, look at PPE and staffing. Completely different issues that we're dealing with first and second. PPE was scarce. I mean, the stories are amazing about what you went through and what you did in order to address the PPE shortage. But now PPE is fairly plentiful and it's available. So those issues are completely different from the first and second wave. The question is more compliance issues. The second, between the first and second wave with staffing, is almost wholly different. You know, there was a lot of fear from staff members about what could happen, and then a lot of staff members got sick. And so there was real shortage of staffing, and even going through your traditional routes of agency that might be available, there was nothing available. And so you're paying heroes bonus, you're doing everything you can get to get people in. What's the issue now with staffing in the second wave? As you probably know, it's more of a political issue. You know, they passed these acts, and with good intention to help people, but it pays to stay home. You know, it's cost. You can make more sitting at home and collecting a check on these government programs than actually coming into the facility. Or even if it's similar, it's hard to get people in unless you really bump up pay to address that issue. So the government, in trying to help, is actually hurt and caused problems in this particular area. But they're two different issues. So two different issues us, as the lawyers defending you, have to deal with when it's a staffing issue. So just kind of make you sensitive to that and why certain documentation, as we talk about, is going to be important. So pending litigation, I'll just go through this very quickly, but I just want you to get a sense of the type of claims that are out there that will come. This is actually a claim against one of the first ones that was filed against Comprehensive Healthcare Management Services. Nothing against Comprehensive at all. It just happened to be the first one, the lead lawsuit. And this was actually for the death of a staff member, but they're structured the same way. First, we'll talk about CHMS defendants and CHMS owners. And the reason I pulled that out in the next one is what they do is they say that every corporate entity that's out there, the operator, the management company, all the ones above it, are all kind of one, and they're all working together. And if you find one negligent, the other ones are negligent. Or it really is all about control and money and control and what you do with that money. So they try to lump everybody in together, which is why that immunity that Amelia talked about earlier is really pointless and useless, because they're not suing individuals, they're suing the operators and owners. Then they talk about the COVID-19 pandemic, and then they go into the various notices. And here I can assure you, they started, when it started in Wuhan, and then what the WHO did, and then when they first gave out the notices, and then when the first case, the Kirkland facility in Washington, when that developed COVID, and then it'll go into Governor Wolf's order, and then the first case that happened, et cetera, et cetera. So they set forth the timeline, and the reason they're set forth the timeline is the same reason we showed you that timeline before. It's really competing timelines. Like, what is the notice that you needed, and what did you do to prevent? And so they're trying to set their own timeline and saying what a standard of care would be, well, it's very important for us to know the notices that came in, what was actionable, why it was actionable, and set our own standard. So there's another kind of aspect to this. The original act that came out, the CARES Act, it seems like it was 1,000,000 years ago. It was certainly like $5 trillion ago. But the original act that came out was back in March of 2020. It seemed kind of quaint. It seemed like a huge thing back then. Now, with the numbers we're talking about, it's just one of many. But basically, it was signed into bills, and it gave certain payouts. And the money was allocated, and different states got money. There were direct grants. There was grants through the state. And it's all formula-based, and I don't want to get into it. Some of the folks that dealt with that aspect of it on the line will know. But what it does is it creates, from a litigation perspective, the question is what money was received, what the entities were involved, distributing or using, and how it was used, and did you have positive and negative returns. So, a lot of litigation is about the money. And so this is about tracking the money, where it went, and was it used for PPE purchasing, for keeping staff, for doing all the things that were necessary to keep the facility safe. That'll be the argument. And then there was this Washington Post article that was out there. This is pretty much was probably at the prompting of the trial bar and some trial attorneys. And basically, the headline here, nursing home companies accused of misusing federal money. The money we were just talking about, CARES, well, they're talking about misusing that money instead of using it for what was needed for prevention and protection, using it for other things. So, this is clearly a plan. This is clearly somebody gave them the idea to look at, and then you hear all kinds of things in this article about no real restrictions and don't know where the money went. And I only bring that up is because you start to get the mindset of where trial lawyers are by some newspaper articles and such when they start citing them. But that's kind of one of the things they're going to be looking at. So the money that came down through the CARES Act, what was done with it during that period, that critical period of time when there were shortages and of both staff and PPE. So I'll run through that, but it's kind of an interesting, like those familiar with the industry, like who's that? There are all these anonymous sources that, like I said, it was clearly prompted probably by a plaintiff's attorney or several. And so then it kind of, let me pull back to that original lawsuit we were just talking about. So those are the types of things that will become important in this for that first wave for sure. And that then the question is, normally this is the type of corporate liability case you see, and now it's being folded into COVID case, and that they're claiming that you were underfunded and understaffed, and then the management created these problems, et cetera, et cetera. So that's essentially the anatomy of what the claims will be. That's what we've seen so far, and that's what we expect. So next thing we're going to talk about then is really the meat of the matter is precautions. What are some of the things you can do to protect and to plan for the future? Well, the main thing you can do is to keep an ongoing timeline. Now, we have probably right now 2021 or such pending type of claims, whether they were letters for records, whether preservation letters that went out saying preserve all your evidence, that kind of thing, or actual lawsuits. So there's about a good number, 20 to 30. And what we've seen the response, and when we go through our protocols and have our sit-down meeting, our COVID meetings, and go through things, the facilities have been really wildly divergent in some respects about how this was handled. So I'm trying to give you some guidelines and some guidelines, and it's never too late to do these things. So the first thing is, do you have a COVID response team meetings and with the key person involved? And keep an ongoing timeline. And even if you have to go back and think about what was done, it's really important to do it now. Louis Freed made this comment back in '92. He used to be the FBI director, that if it's not documented, it's not done. You've heard in your industry. What he said was that if something is committed only to memory, then the chances are that it will be lost because memory is lost over time, right? And when you commit it to paper, it's not really lost as long as you keep the paper or put it on a computer. But if you just commit it to memory, you'll forget. I mean, it's just the nature of the way the human mind works. So it's really important to get that timeline, to start thinking about that. What did we do? What did we know here? What did we do here? What did we do here? And communications that are involved in that. So written notifications, oral discussions with the local Department of Health, the State Department of Health, discussions with external parties, getting ID involved, what have you. Some facilities that contracted directly with infectious disease physicians to give guidance as well. That type of stuff is huge because it shows all the proactive things that you were doing in a really just devastatingly challenging environment. So it's what was acted upon and why. So even the notices that are come in, what you found were important and what you needed to do and why. And that might be self-evident in the guidance you were getting, but it's also important to the extent it's not so self-evident or a reason why you didn't do something, to document that so that you have ongoing documentation of those things. Because again, we're setting the standard of care. Create resource binders, folders, electronic files. Keep all the documents related to COVID, whether considered important or not. You might not consider it important, but it actually may be important from our perspective for defending you. So all forms of documents, written memos, notices, etc., electronic records, emails, text between Department of Health or anybody, surveyors, posted signs and warnings. And one thing you can even do is just take a picture of where the signs are and post it, or have a diagram of where each posted sign and warning. Literally have a case, it'll probably go away, but it was about a transport of a resident from one place to an outdoor visitation area and not wearing a mask, and the claim that COVID was contracted during that transport. Seems pretty far-fetched, but nevertheless, that's a lawsuit. And so we actually have some video of that was preserved. But the point being here is, what notices were put in there and how they did things are memorialized just for that particular section, because that becomes the focus of the litigation. So even if you don't think it's all that important, it doesn't matter. If it's related to COVID, best to keep it. Floor plans, cohorting documents. We know cohorting changed over time. Keeping them in one section, keeping in place. So when it changed, why it changed, and how you were doing that, even on a diagram, is so helpful for us later on. Video, again, video is actually can be problematic in occasions because a lot of video that has been used, it's been used adversely because of staff not wearing PPE or pulling PPE down. By the way, I had doing a facility site inspection and had to wear an N95 and went through and probably spent about an hour with it on and couldn't wait to run out the front door and rip it off my face because it was so god-awful uncomfortable. And I tell that to other attorneys, especially plaintiffs' attorneys, that you don't know what the staff have gone through and how difficult it is sometimes to do their job, and that what seems like something on paper, living, is completely different. So I do commend you along those lines. Policies and procedures before and after COVID, infectious disease protocols, PPE use and allocation, quarantine isolation, cohorting, visitation, admission, readmission, education. All the education is really important because training is going to be one of the big ones. And so it's materials distributed, online courses, PPTs, competency testing, resident family education. That's really important, that they understand what's going on. PPE is for the first wave. Second wave, not so much. First wave, it's going to be huge. So anybody that passed during that period of time, documentation about what you went through to try to get PPE and the critical shortages that were there. Inventory logs, purchase invoices, testing, sterilization, sanitation supplies, fit testing equipment to the extent you were doing fit tests for the N95s. All that is really, really important. Staffing information, daily staffing, call-out information, efforts to maintain staffing. Again, these are two different issues we're talking about. For one, the first one, a lot of healthcare issues. For the second one has been more an economic issue. So it's really important to know what the staffing is and the challenges, and to make it very clear what you did to try to keep and maintain staffing levels. Notices and waivers, very important for the visitations, and you're going to have that now with a loosening of allowance of visitation. Employers, families, vendors, complaints, grievances, very important to keep. Communication, all communication we talked about, internal and external, including with suppliers and the family, of course. And building plans, we talked about that before, floor plans, cohorting plans. So we talked about timelines, but real life stories too. This is kind of the last thing that I want you to think about. It's amazing. If you talked about somebody with from 9/11, usually that was burned into people's minds and they really remember. But there's little things that happen. And as time goes by, you start to forget about it. You feel differently about things. So it's really important to the extent you went through extraordinary things or your staff was extraordinary, to just make a note, to jot down a note or just talk about it, put it somewhere that you can look at and say, oh, I remember that. Yeah, that was pretty amazing. What we did, and just kind of looking back on how we survived this. And those things are really important because a jury is not going to hear those cases for years. And their perception of COVID is going to change over time. But you need to bring them back to what it was really like back then and what it was like for healthcare providers like you. And so it's really important, to the extent you have those stories and specific staff members are involved in them, really important to document that. I'll turn it over for, liability waivers. Let me put this real quick. We talked about that a little bit in there. Have those liability waivers for now, especially now as we're coming out of this, but we still do have COVID problems. And most of you are doing that. Most of you are doing it on a corporate level. But it's really important that you have these liability waivers out there for people coming in, not only that they might spread to the loved one, but it also can be spread to them. So you might have this third parties that are getting COVID allegedly from facilities. So it's really, really important that in your visitor logs and allowing visitors that these things be put in place. Amelia's going to give you some statistics and then talk a little bit about some other things, including the apology legislation. Amelia?
All right, thanks. So just some interesting statistics on kind of where are we with vaccinations of long-term care staff and residents as well. The Department of Health, as some of you are probably aware, and some of you may have submitted information to the Department of Health in advance, that the Department of Health gathered some information and published a survey at the beginning of April regarding specifically the skilled nursing facilities and their residents and staff with vaccination rates. And it was published with kind of each by county, kind of the acceptance and declining rates of the vaccination as to both residents and staff. Kind of compiling all that information together, there are about 45% on average, 45% of skilled nursing facility staff had declined the vaccine as of time of publishing that survey on April 15th. However, the resident vaccination rate averaged about 77%. And I'm sure you all know what's going on in terms of your own individual facilities, but it is interesting to see. And of course, I'm sure you're all, dealing with the issues of rights of refusal and things like that. But the vaccination rates for residents is quite high, with some staff still declining the vaccine. And the CDC is also compiling information. They seem to be updating it every day. They estimate that 47% of all long-term care workers in Pennsylvania have been vaccinated to date. And that's not on the lower end. I mean, that is kind of the middle of the road. There are some states that have higher reported rates, but there are some states that still have only about 10 or 12% of their long-term care workers vaccinated. So it's just interesting in kind of these, statistics kind of moving forward. And again, kind of as Bill mentioned, as, more visitors are going into the facility, as other restrictions keep on lifting, just kind of the impact of vaccination rates kind of going along with all of that. And then finally, just quickly, we'll go over Pennsylvania's what's called the benevolent gesture law, and Bill had mentioned it's kind of, the apology legislation that we have here in Pennsylvania. So it's just something to kind of keep in mind, as you're communicating with residents and their family members. So it provides that certain types of statements can't be admissible as evidence in these types of lawsuits that we've been talking about in advance. So it applies to liability actions, administrative actions, mediations, or arbitrations. And it applies to the statements made by the healthcare provider, including, any officers, employees, or agents. So what kind of statements are protected is what's called the benevolent gesture. So just an apology. I'm sorry for your loss, those kinds of things. Those types of statements cannot be used or admitted as evidence as any sort of admission of fault. And it has to be, we'll get into a little bit of some of the nuances. But again, so the exceptions to that would be any sort of statement of negligence or fault. So it is a bit of a fine line, apologizing for the loss, particularly during this time. You've all been going through this just as much as the residents and their families. So a genuine apology for the loss is something that, you're not robots. I mean, this is a loss for obviously the families, but for the facility as well. This legislation is meant to kind of protect those kinds of statements and not be admissible as evidence. And of course, it's the conduct, any sort of directed statements towards a patient, relative, family members, or friends, or any of their personal representatives. So different kind of something just to kind of keep in mind. Again, just to always be careful about what you say, and certain kind of preparations to kind of implement this in your facility. Kind of maybe identify what we're kind of calling facility champions, whether that's a social worker or someone else on your staff that communicates directly with the residents and families, and make sure to kind of create a uniform policy and procedure regarding certain language that is advisable versus, kind of, again, those little fine lines of saying anything that could be interpreted as any sort of statement of fault or responsibility for what happened to a particular resident. And just education, making sure to educate the training of the staff and training the trainer, just to kind of keep consistency among all of your staff and those that are speaking directly to residents and families, just so that there's kind of this clear, consistent communication with them regarding, offering your condolences to residents or families. And that's kind of it.
Thank you, Amelia. Just to follow up on that, one of the things we've seen is that with litigation, especially when they were doing a lot of the advertising, newspaper advertising about survey results, most families, and just asking them about this, most families went to lawyers because they felt like the facility had not communicated with them. Okay, so that's why communication is so important. And they went to the lawyers because they figured they could get answers. And the lawyers know that. So that's why they started, creating advertising that raised questions in their minds to have them come in, and that's how they got the cases. So it's really important to me, just in seeing this over the years, that one of the best preventive measures is to keep the family informed and to keep them advised. And so it's not so much of a shock and they go that route. So that's the end of the presentation. Amelia, thank you. If you have any questions, we can take them now. We've probably got a couple minutes. Otherwise, we are certainly available to take any questions by phone at the office or by email.
Great. Thank you, Bill and Amelia. We really appreciate the information that you shared with us today, and we are open for questions. At this time, we do have one question in the question box. So if there are any other questions, please feel free to type them in the box. The first question that we have is, if the new bill were to get approved, would it be backdated to when COVID started?
That was the plan by the legislature. I can tell you that the governor's already said that he's going to veto it, even if it gets past the Senate. So it's kind of stuck with the Senate right now, and that's why PHCA is trying to work very hard. Zach is trying to get a deal where either some legislation goes through, there's some other measures that have been talked about, but basically to impose those liability protections, and they would go back to when probably the first emergency order was issued.
Great, thank you. Again, if there are any other questions, please type them in the box. We still have a minute or two to take questions. there are any. There's a lot of information. Next week, we have another Burns White webinar on May 12th, and that one's going to be around human resource, policies and things like that. So if you or anybody else you know could benefit from that, check out our website, and you can get registered for that. We just had our biweekly education email go out today, so that webinar is outlined in that email that went out today. All right, I don't see any other questions, so we'll wrap up. Again, just a reminder to stay on to complete the survey. Today's webinar is being recorded and will be made available on the PHCA website, and be sure to check out, our other educational opportunities. We've got the Assisted Living and Personal Care Home Summit, which actually is really geared toward all long-term care workers. It's a leadership focus this year, and we believe that everyone can benefit from it. So look for that information. That starts on May 18th, and then again we have the May 12th Burns White webinar coming up next week. So check it out. And stay tuned for more webinars coming out in June. Again, I want to thank Bill and Amelia for the information today. Great presentation. And I want to wish everyone a great remainder to your day, and stay well.
Thank you, Wendy.
Thank you, everyone.